Lightning like Steve McQueen. I'm in the fast lane when the light turns green. And I built tough, I ain't nothing but grit. Cause I made rugged blood, sweat, and spit. Yeah, like a horse I fly. Better push yourself in for a bumpy ride. I like to play hard, but I work harder. And I weather the storm cause I'm built stronger.
What is up, ladies and gentlemen? We are back. We are live. It is the Freight Coach Morning Show, the top morning show in transportation, coming to you live every single weekday, 8:30 a.m. Pacific, 10:30 Central, to break down some industry headlines for you and provide some insight and some clarity into what do all of these articles actually mean. And I bring on guests who are smarter than me, who can break some of this down into even more plain English when it comes to some legal issues and lawsuits and everything else, which we'll be breaking down today. There's obviously some news yesterday about a pretty big countersuit between two very large companies out there, and we'll get into all of that here. But as always, you guys, the people who keep this neon light on for me every single day are my friends over at VHub. VHubApp.com, you guys, hit them up. The access to trailers is imperative for both brokers and carriers alike. Whether you're a one-truck owner operator, you shouldn't have to shut down if your trailer's in the shop for whatever reason. They give you an opportunity to go on there and get a short-term reposition or a short-term rental for you to utilize and stay in business. And then furthermore, brokers, we need to get out there and create a drop trailer pool at our customers' facilities. You got to think outside of the box, and they have that right now for you. On their website, what we have going, you guys, Glade Spring, Virginia, going to Orting, Washington, which is just outside of Tacoma. You get paid $15.50 to reposition this, you guys. Talk about a way to help offset some of these rising fuel costs. And I know some of you are going to say there's not rising fuel costs because they're technically dropping, but they're still astronomically high. This is a way for you to get in there and then get some additional revenue on top of the freight that you put in the back of that trailer. They also have them over in Paragould, Arkansas, going up to Orting, Washington. And then where Ron Burgundy is from, down in San Diego, going over to Irving, Texas, get paid $600 to do that. And then also going down to Houston, Texas, $600 to do that. These are ready to go right now, you guys. Hit them up, vhubapp.com. Stacey Steen, she's already in the audience, as well as my friend Xavier Campos. He's in the audience as well already. Hit them up. Let them know that the Freight Coach sent you, because they're the ones who make this show possible every single day. Carl Stiers, good morning. Stace, what's going on? Let's fucking go. You are correct. Drew Driscoll, what's up, sir? Let's get after it. And I have the one and only. You guys see him all over LinkedIn all the time. He's coming at you left and right. He has one of the sweetest logos ever, and it's a picture of his face, Mr. Matthew Leffer, the armchair attorney. What's up, brother?
Ready, set, law. Let's do this, Chris. I'm so excited to be here and talk about really interesting legal issues. And we have some interesting stuff today.
We really do, man. What's new in the world of the armchair attorney?
All sorts of things. Let's see. We have a law firm. That's what we are now. Armchair attorney. Used to be a consulting firm, but now we're a law firm. It's just me who owns it. That's what we do. I have a Twitter account. I've been working on that. That's been really exciting. And then I read a lot about law. And so that's the newest stuff for me right now.
I like it. I just invested in working with a marketing company who's going to help me get my exposure out there on like Twitter and TikTok and everything else to continue to grow the brand, because that's, honestly, that's what it's all about, man. You got to start. And fortunately, I'm in a position where I have the resources to now I can invest in that and have somebody edit a lot of these daily show clips for me to get out there on other platforms. And, it's a process. It takes a lot of time, a lot longer than a lot of people want. And I think that's why a lot of them fall off with doing it. And, I'm glad to see that you're out there doing some shit out there. Are you Stace? Are you hearing me all right? Is everything coming?
I'm hearing you just fine. Absolutely.
Okay, perfect. It might just be Stace then. I get nervous when it comes down to it because, at the end of the day, I'm just a one-person operation.
That's right. We are juggling the balls right now.
That's right. Stephen Mason, good morning. He was out there on the show yesterday. You guys hit him up. 40-foot hotshot, Tampa, Florida. Dan Hellman, what's up, brother? Eric Johnson, the man, the myth, the legend, a.k.a.
Hey, Eric.
The author of the article we're going to be breaking down here today. Hey, we're at day 82. This is the 82nd Freight Coach morning show already. We're on a roll, sir. Absolutely. And it is, there's also a subtle reminder of there being a truck parking issue as well as a facilities issue in this industry, and one that I will not stop talking about until there is some actual change that's out there in the industry. And that comes in the form of all my driver friends when they stop sending me shit that, hey, here's another one for you. Also, Again, I don't know why people are celebrating this, but diesel did drop again to 5.13. I'm happy that it's going down, but like they're trying to say like, oh, look at this massive price drop. It's so good. It's still almost $2 a gallon, year over year higher. Do you just want to jump right in? I
kind of do it, man. We don't need any more updates. We have things to talk about. We have law.
We do have things to talk about. Chances are this show is going to go over 30 minutes today, you guys. And frankly, I do whatever the fuck I want. It's my show.
That's right.
Let me see here. Simon, good morning. DJ Shirley, what's up, dude? This article was written by my friend Eric Johnson. DAT Convoy embroiled in anti-competition legal battle. This is from the JOC.com. Hit them up, you guys. They're one of my most trusted sources of all things news that's out there. Before we start talking about this, man, so Matt took it upon himself to fucking like print off all the counters. He fucking read everything for you guys. So he is way more prepared than I.
Papers. So many papers. Look, this is interesting because we don't often get to understand the inner workings of the legal system. And so whenever I think about legal topics, my goal is always to find primary sources, to find the actual things the lawyers said, and to figure out what it is that they mean when they say what they put into the media. And the article is great. It gives you a good overview of what's happening in this battle. But what I would love to do, if you would humor me, is to give a little bit of what we would call procedural history. Talk about how did we get here? How did we get DAT suing Convoy? One of these wonderful Silicon Valley, kind of out of Seattle, unicorns worth over $1 billion. I think it's maybe 2 or 3 billion at this point in terms of their valuation. Here's the deal. Convoy says we want to solve a problem, and that problem requires us to make an app. And the app goes to the drivers, and the drivers can find the ability to get work through the Convoy app. But Convoy still needs to have more driver capacity, just like any freight broker. Where will they find that capacity? Well, there's a company called DAT, which I assume maybe some of your audience has heard of at some point or another. And what DAT says is, we would love to work with you, Convoy, but there's a few conditions. The first condition is you must never make a load board while you work with us. You also have to have exclusivity with us. And if you don't have exclusivity, it will cost you more. And Convoy, being an interesting up and coming company, says, we need the capacity. We'll sign anything that you give to us. As time goes on, Convoy realizes that they don't necessarily want to have exclusivity with DAT. And so they make an amendment to the contract and say, hey, instead of this 3-year contract with all these different bells and whistles, let's move out this exclusivity. And I'm going to make a note here because you'll see a lot of this talk of the exclusivity clause in this contract between Convoy and DAT.
Correct.
I read the document. So the cost per month for Convoy to have DAT as an exclusive provider was $47,500. To not have exclusivity, it was a very much higher number of $52,500, $5,000 delta. Listen, for people who are watching this, $5,000 a month for either one of these companies is not even a rounding error. You wouldn't even write it down. There's no reason to write it down. It's nothing. It's nothing. So the argument about the exclusivity is a little bit tenuous. Anyway, back in November, DAT learns that Convoy is going to be launching a new product called Convoy for Brokers, essentially giving the tools of being a brokerage company to brokers to use Convoy's network of drivers. This is the idea of finding capacity for your drivers. And DAT was not happy about that. They decided, well, how about we break this contract, we terminate it, and we sue you. So in January of this year, 2022, DAT sues Convoy for breach of contract, among a bunch of things. Convoy does a pretty decent job of saying, wait a second, we're not going to answer this. So this is when we talk about what it means to have this kind of process. You file a complaint.
Yeah.
The thing that happens after the complaint is either a motion to dismiss or you answer the complaint and then you add whatever counterclaims or defenses you have. Yeah. So Convoy motions to dismiss a whole bunch of things that DAT says. Those are ongoing. We're not going to talk about those ones.
Yes.
But Convoy does answer one of the things about the breach of contract with the non-competition agreement. And we talk about this all the time. Non-competition agreements are common for employees and their companies. They're also very common in businesses. So people should understand this. So what ends up happening is Convoy makes their answer to the complaint and a counterclaim. That is what we received in June 17th of 2022. That's this document with 43 pages and all the exhibits.
So they're going on, and and Eric points this out in his article, that they're in their countersuit, they're alleging that DAT engages in monopolistic behavior by forcing brokers and carrier customers, which pay subscription fees to access the load board, into a non-compete agreement that prohibits them from developing more advanced load matching products and services. What's more, Convoy alleges in the countersuit that by charging higher subscription fees to its broker customers that want to use other load boards to find available cargo, DAT is engaging in behavior designed to insulate itself from the competition. When Convoy did buy itself out of DAT's exclusivity requirements, Convoy found that competing services lacked coverage and quality because DAT had locked up substantial portions of relevant market and denied others access to data, the broker said in its June countersuit. And yes, I did just chuckle a little bit there because it's kind of funny to see somebody, especially an attorney, wording it in that capacity the way that they did. From your perspective, Matt, how, if you were, people steal ideas all the time.
Yes.
Let's, but that's why there's contracts in place. I'm a startup in a sense, like I'm a young entrepreneur. I've invested in contracts through my attorneys to ensure that I'm protected in the event that somebody does try to steal what I do and try and put it off on their own. You see it all the time. And I'm honestly shocked at some of the claims that Convoy kind of threw out there, trying to cry big bad wolf about all of this stuff. But to me, seems like it's a very standard contract that any company would have their users sign to protect them, because, not all of us have hundreds of millions of investor dollars like a certain company who's named in this lawsuit that can just build shit and waste it all and not be profitable, So like, you got to protect yourself as a business. So like, I completely understand why DAT, amongst other software providers in this industry, would want you to, and actually have you sign a contract. Like, that's not an anomaly that there's contracts that are signed out there. And that's kind of like my perception of how they were trying to make it. It's like, oh, they're just doing it to take on a monopoly. Well, I would also argue that that's exactly what Convoy is trying to do in this exact same manner, by saying, hey, we're a broker, but we also want other brokers to put stuff on there because we have access to trucks. You have no more access to trucks out there than any other fucking broker on the face of this earth. And clearly, based off of this lawsuit, you stole it from somebody, and now you're trying to pass it along as your own.
This is an interesting question. So just to give some background for the viewers, when you're having software companies making deals together, almost invariably you have some level of, don't take what I do and do it against me. Because end of the day, all you have to do is get some developers and you can mirror just about anything, whether you do it onshore or you offshore it. Software is the thing that's very easy in some cases to replicate. Now, the solution here of what DAT is asking for in their complaint is to have the entire Convoy for Brokers product get dismantled and destroyed. That's absolutely not going to happen, I think, unless we find something in discovery. So this is the thing we should talk about next.
Yes.
So after you have these complaints and all these paperworks back and forth, then you get discovery. And if anyone's watching who's ever been involved with litigation, about discovery, requests to admit, you look at this request for production, you have all of these different questions that go out, and then we'll find out where the information came from. But for someone like Convoy, looking at how load boards function, they can easily understand how they work. I mean, essentially, you have driver capacity and you're finding people to move things that you already either agreed to move previously for a contract, or you have a spot number you're going to be moving. So the non-competition agreement within this contract isn't that surprising. I do think these counterclaims are really interesting. So the counterclaims that Convoy puts out, and this is what's so interesting, is the article we talked about, we just covered the counterclaim, anti-competition. You are violating the Sherman Antitrust Act. That's what's being alleged by Convoy. But we got the motion to dismiss that just a couple days ago, and I read it last night. It's very interesting.
What does it say? Come on, please do tell.
On one level, Convoy does a thing where they plead in the alternative. They say things that almost seem opposite of each other. You have to do that as a lawyer. But what Convoy basically says is, no one else in the world can do what DAT does because they have such a huge market share. We talk about the numbers of 40% of all truckloads touch DAT. That's a number in both the filings.
Yeah.
There's another number of 64%. Now, a lot of people have come and said, Matt, why is this 64% number even relevant if we're going to talk about 40% going on DAT generally? It's 65% or above can sometimes show we call a prima facie case, or a case that there is something happening. It's violating antitrust laws. That 65 number is really important. Now, they couldn't get to 65. They got to 64. But in any event, Convoy says we built what DAT does, but better in less than a year. And we have so many other load boards. There's Truck Stop. There's 123 load boards, a whole bunch of load boards. So to think that there is actually a barrier for people to enter that market, for me, it seems disingenuous. It seems probably not accurate, but Convoy has to have something to continue this litigation. And this is what makes this case so interesting. We have a very well-known company, Dial a Truck, right? This is the people who you'd call to get a trucking company. For decades, they've been doing this.
Correct.
And then you have a company who's from 2015, 2016, that's raised hundreds of millions of dollars that has the opportunity to potentially disrupt what was there before. And this is the nature of the Amazon world. If they can find a way to mirror what you do, they'll do it. The big question will be, as we go through possible discovery, is what information was used by Convoy to make what they made? If it comes to be that they used a bunch of DAT stuff, that could be very, very challenging. But again, $5,000 a month additional for the exclusivity. This is silly. This is a silly thing to talk about, but it's really fun. It's really interesting.
Yeah. It goes on to say in here, in the article, Convoy could not have built and did not build its pricing algorithm or otherwise create a functional load board without using and misappropriating the proprietary data and trade secrets it was accessing for improper purposes on the DAT load board. This is what they had said in the lawsuit back in January. Convoy independently has no meaningful long haul history, rate history, land history, or other data that would be required to develop and operate automated, algorithmic driven digital load board like Convoy for brokers. And now the timing of the lawsuit and everything is pretty much in line for when Convoy came out and said, hey, brokers, come post your shit out there, because
that's exactly why they got sued. That's exactly why they got sued.
Exactly, because essentially it was hey, we need data for our algorithm to work. For what we came up with, whether they took it from DAT or not is up in the air. I don't know. I don't have access to anything internal. But as somebody who owns a software company, I know data in transactions are key to building out and truly having the functionality of your platforms work at optimal levels. Is you need a fuckload of data. So why not? I'm not arguing why Convoy did what they did by opening it up to all freight brokers out there to try and get a bunch of shit, because who knows? Like, this might be a smoke and mirror for a long-term play that has nothing to do with anything other than a data dump. They want to buy up and get as much data as possible for a larger play that is yet to be seen. Probably something along the lines of optimal rating or something along those lines would be my guess. Because frankly, at the end of the day, another load board isn't necessarily what the industry needs. Like, let's call it what it is. Like, we don't need another load board. They're a broker. They've been a broker. They've been trying to throw a bunch of different terms behind what they're after, but where I come from, you can put lipstick on a pig, but it's still a pig. And it doesn't matter how you try and slap on what you're doing. A freight broker is a freight broker, no matter how you try and spin it, no matter what fancy marketing firm you hire to come up with a new slogan, you're still brokering freight. And then frankly, you're taking people's data at that point and you're trying to use it as your own. And that's what a lot of people are against is, again, like at the end of the day, no broker has a fucking stronghold on pricing. Like we all kind of bid it the same way,
Well, a couple of things worth noting on Convoy specifically. So again, like they started off as being a broker with truck drivers that download the app, whether it's 80,000 or 150,000, whatever number they have of people that use their app to do something.
Kajillion.
Yeah. Then they go to the shippers and they say, we have capacity for you. Yep. You can give us the information. Then they built out their trailer pool. So Convoy, if I'm not mistaken, has over 3,000 trailers now. So they have a part of their business that has some level of asset incorporated into that. And so what they see, at least I would assume, is they see we can displace these intermediaries. All you have to do as a shipper is use our technology and we'll hook up with everybody else. And if they can get the brokers to see this value, maybe they don't need to make the 20% or 30% off a load. Maybe they just need to make 3 or 4%. I don't know. They're not publicly traded. We can't find out.
Fuck is making 30% on a goddamn standard dry van though? That's
I have no idea. I just think that what they see is a way to take out existing companies that were to a certain extent passive in what they did. I mean, the way that these load boards work, I think they have a path to disrupt some of these things. And even though they are a typical broker in some context, their goal is to get software into every single thing. Uber Freight probably doing the exact same thing to an extent. There's a lot of talk in these lawsuits about digital native company. And I think that's kind of a thing we should just briefly plant a flag on.
Let's do it. Flags planted.
Many software companies say, you don't understand us. We're digital natives. We've always been digital. You can't understand. You're just too old to get us. And I think that's a really stupid argument because every company that exists today is a combination of technology, processes, and people. And you have to have some technology, whether it's whatever it's out there, whether it's your TMS or whatever else. So I do think that at the end of the day, Samantha Jones.
She's here. What's up, Samantha?
Fan. I didn't send you all those things.
What's up, Freight Sensei?
But I think at the end of the day, from my perspective, I think we're going to see that Convoy likely breached this contract. They knew what they were doing as they built this, and they're going to have to pay something. When you go to court, you go to pay money. That's civil litigation. But how Convoy is positioning themselves is to say, we are here to help the little guy. We want to help the brokers get away from DAT.
Of course. Of course. That's what
we're trying to disrupt the status quo. And all of this material, all this litigation is going to give them such a wonderful potential marketing push. Honestly, I think Convoy believes they're going to have to pay something. Even if Convoy loses this publicly, they're going to win this. They're trying to build tools for brokers. They're trying to make it easier to be a truck driver. And what is DAT doing? They're just trying to stop innovation, trying to club us from being able to do the innovation that the industry so desperately needs.
Or, in my opinion, based on this, because again, like I can't go back in time this quick and say what I said about when Convoy for Brokers truly came out. I can't fucking remember. Somebody I'm sure will call me out if I said it any differently, and that's fine. It seems to me that this is a way for them to steal data and use it to their advantage. They're not there to help. I don't think that that's the case, and I'm not saying that Matt's saying that at all in this instance. I think that, you know, when you're a broker and you open up your network to other brokers, I think that is pretty fucking stating that you can't do your job, you know, for starters. If you're a broker and you need another broker's help to move your customers' freight, that is in your wheelhouse. And it's not like they're like, hey, we're opening this up if you have because we have all these special project freight that we've never done before, and we'd love to partner with a specialized broker in a way. But that's not the case. It's like, hey, just come put your shit on our load board and then everything else. But again, I think that it's just so funny to read, because you're right. Like at the end of the day, you can't pay for the publicity that they're going to gain.
Oh, absolutely. And what Convoy does, when they got rid of that exclusivity, they were probably, and they couldn't talk about the other brokerage or load boards they were using. But my expectation is they probably got a whole bunch of different load boards, experimented with them, and said, okay, brokers have to use all these different tools. We think we can improve on this one and that one and this one. And rather than taking the data necessarily, they probably, again, they might have taken the data. We don't know that. That'll be discoverable. But what they might have also done is say, let's look at the user experience, look at the user interface for all these load boards and say, can we simplify it? Because I don't think at the end of the day, Convoy expects to be considered a broker for all time. I expect they want to be just software to help you do something, because that's the multiple. That's the multiple of whatever your revenue is times 5 or times 10, not EBITDA, that kind of nonsense.
Sounds like they want to be DAT.
They probably do. I mean, they see the money. Everyone wants.
Well,
a piece of
you
the
got to
money.
think if you're a broker and you're coming up and you're signing an exclusivity, because again, $5,000 to that, like that, you're right. That's not even a rounding error. Like they're not even, that doesn't even move. That's like that falls into the true up at the end of every month of, oh, hey, we're fucking $50,000 or whatever that number looks like. But when you work with a company like DAT, they are the biggest. They have the largest market share that's out there, but they've also been around the longest. And I think that, again, you just never know. You never know people's intentions, but this is back to my original point. This is why you have contracts, though, you guys. Like, this is why, like, I would love to think that everybody has my best intentions, but that's not the fucking case. And you go ahead, lawyer.
Well, I was going to say, just for the audience, like, I think it's really interesting to kind of see how lawyers make this argument. Let's look at the exclusivity thing as a really good example. From Convoy's filings, they say, we are being penalized. We're being penalized for this. And then you look at how DAT says, no, there's no penalty. It's a discount. You use just us. It's a discount. And you get to see how lawyers approach the same set of facts and then make the adjustments. Now, I will say for the Convoy part of it, I can imagine them when they're running their series to run another round of funding and they go, listen, we need to increase the fund by at least $200 million because DAT is going to penalize us and we're going to go out of business and we got to be ready for that. And I don't think that happened. And by their pleadings, you kind of think, oh my gosh, they've just broken poor Convoy with this massive fine. $5,000.
I know, $60,000 a year. Fuck me. How shit. That you know what? That's probably why they laid everybody off earlier this year.
That's gotta be. That
had to cover their fucking lawyer fees.
Someone needs to get something in here and do a chart of like when the layoffs took place and then when that
the layoffs took place. It was like fucking May, bro. Like
that's right. Okay, that's right.
Yeah. So I mean, the
fines went up a couple of years ago, so I guess it wouldn't.
Yeah, but the counter filed in June. You got that's at least a couple $100,000 versus lawyer work.
Could be. So to conclude, let's look at this case. So you have two highly sophisticated organizations. Don't feel bad for either one of them. That make a contract that has very specific terms. They know exactly what those terms mean. Like we as individuals might go, I didn't realize the non-competition agreement meant
your own fucking fault. You got to know what you sign. Like
these
frankly,
are well-funded businesses.
I do not blame any business out there for having a contract in place to protect the business, because at the end of the day, nobody, you work your ass off to build companies up. All right. You put in more effort than you could ever fucking imagine. And it's not just a physical, a mental battle, time away, all of that shit you put in. You need to fucking protect yourself with contracts. All right. Because people out there are not your fucking friends. People will smell blood in the water and they will fucking slit your throat just because it's a fucking Tuesday.
And software even more so. The fact that you can mirror, I mean, looking at VHub as an example, look at Airbnb. It's just okay, how do you do this? Okay, make the software do the same functionality with a different use case. This is software, man. It is a knife fight every single day. And at the end of this litigation, here's my expectation. I think Convoy loses this battle.
Oh, yeah.
But I think Convoy wins the war ultimately. Because if they actually have the technology to do the things they say they can do, they will find a way to reduce the cost of doing the transportation. And just like the folks at Proposition 22, when it comes to California AB5 stuff, they're exempt. They are exempt from the application of AB5 with their owner operators because they're a software company. It's fascinating, dude. It's fascinating.
I know. God, and just to think, all you got to do is hire a very expensive lobbying firm. You can get whatever the fuck you want in this country. Sorry, different conversation for a different day. Yeah, dude, I think that it's going to be interesting to see how this falls out. This also could be a fatal error for companies as well. When you're out there kind of, I don't want to say poking the bear per se. Like I understand, I see why, of course, Convoy is going to try and look like the victim. And, that's because that's what lawyers do. That's why we hire armchair attorneys.
Right.
And he, as you guys could see, Matt is were you in drama club or acting in high school?
I did dabble, but law is a performance art. I mean, you take words and you have to craft a way to look at them. And this example of exclusivity is perfect. It tells you how to take $5,000 and make that into a whole very interesting thing.
I know. As I'm drying my tears with $100 bills and legal fees here, I'm going to come up with how this is we're the little guy and we have a multi-billion dollar valuation that's out there. I know these are all schematics. We're all just fucking around at this point. But again, it's like, this is why we need lawyers to come on here and talk about this stuff, because it is, it's interesting to see. But I think like how you apply this to, like, back to what I've been alluding to, you guys, like, it doesn't matter what size organization that you have, you need to have contracts in place to protect yourself, especially if there's any IP, intellectual property. If there's anything proprietary that you're working very fucking hard on, you need to protect yourself. You need contracts. And to sit here and say like, oh, I didn't know what this all meant. Get the fuck out of here. You know exactly what it was. You got caught. You got sued for it. And now you're just going to play the lawyer battle. And, you know, your lawyers are drying their tears with their $100 bills. And, you know, go
what
ahead.
I will find interesting will be, so one of the parts of the counterclaim that is put out by Convoy is that they expect, or they believe, that other companies have to sign the same exclusivity contracts and non-competition contracts. And DAT, for their part, says, you don't know that, Convoy. You're just guessing. And that doesn't amount to violations of anti-competition statutes. So what will, if it gets past this motion to dismiss that has been put out, we'll probably get some discovery potentially as what other types of arrangements DAT has with other brokerage companies that are in this space. And it's going to be fascinating. I mean, we are going to learn so much as an industry about how these things work. And it's fascinating. And I'm hoping everyone who's watching this is like, all right, that sounds interesting. I'll follow along.
I'm looking forward to it. You know, because like, honestly though, man, like selfishly, as somebody who's trying to build shit up, I learned from this stuff, man. Like I learned from this on how to protect myself, you know, because that's what you need to do. Like you got to get out there and you got to protect your business. And these are opportunities for you to learn from it and see like, all right, cool. If you like, say you're a broker out there and you don't have a broker carrier agreement, you need to have a broker carrier agreement, brokercarrier.com. But it's one of those situations. Go ahead. No, you go ahead, lawyer.
I was going to say, one of the things about Convoy's counterclaim is they demand a jury trial. And so what they're asking for is they want to go to court. They want to litigate this. For everybody who's following this, this is what the next stage is going to look like. There will be this motion to dismiss, which was filed by DAT. Convoy will respond to that motion to dismiss. And once we get a dispositive ruling by the judge in the other claims that are being fought against on motions to dismiss, we'll have essentially the pleadings and both answers to the complaint and the counterclaim. Then we go through discovery, which can take up to 90 days, maybe longer, probably longer, based on how interesting this data likely is.
Yeah.
And then once all the discovery is done, then there's going to be expert witnesses that'll be retained and deposed, and depositions will happen. So it goes written discovery, then it goes to oral discovery, like deposing people. All of this stuff at some level will be able to be kind of followed along. But then it goes eventually to a trial. I will say this for everyone watching, 95% of cases settle. I have zero expectation that this will actually go to the full trial. But if it does, we should all go and watch it.
Matt Leffler and I will be live from the courtroom.
They're public. We can go.
Dude, that's exactly it. I will, dude, I got your flight. I got your hotel room covered. Me and you are fucking going, and we will do the live show from outside the courthouse.
Courthouse, we'll like Harvey Levin. We saw today in the deposition. Oh, that'll be great. It'll be amazing.
Dude, that's exactly what we're going to fucking do. If this goes to trial, we are fucking there.
I think DAT and Convoy, you have an incentive to settle now. If you didn't have one before, you have one now.
No, dude, we'll just be out there fucking interviewing people as like, hey, you want to comment for the Freight Coach Morning Show?
Let's go to the judge. Be great.
Yeah, dude, that would be fucking great. Oh my God, I love it. Matt, yeah, that I know we went a little bit over today, but hey, as always, man, I appreciate you joining. How can anybody reach out to you and find out more about what you guys are doing?
Find me at armchairattorney.com. You can find me on LinkedIn, Matthew Leffler, or look up my company's name, Armchair Attorney, or Twitter, Armchair Addy, ATTY. ATTY is the abbreviation for the word attorney. It couldn't fit the whole name on Twitter. As always, thank you for having me, Chris. I love talking about the law, and hopefully your audience had a chance to learn a little bit more about a little case between a little up-and-coming company called Convoy and the big bad DAT wolf.
I love DAT. Anyways, we're on to that for today. We'll be back tomorrow, you guys, 8:30 a.m. Pacific, 10:30 Central. The Freight Coach Morning Show. We are the top morning show in transportation, coming to you live every single weekday, you guys. As always, I appreciate you guys so much. If you saw value, share the show. All right. If you see value in what we're doing here every single day, share the show. That's how this is all going to continue to grow, is through each and one of you all. I appreciate you guys all so much, and we'll be talking to you soon.